So Rob, I want to come on to one last topic with you at this stage at least, and that is a section of your statement that's entitled, "Are the issues or failings confined to Essex?" You've identified this morning for us themes arising in Essex, and of course we've seen the very serious issues arising from the cases of Mr. R and Matthew Leahy. To what extent are the issues you've identified in relation to Essex confined to services there, or are the Essex themes representative of what's happening more widely?
Objectively, I don't know the answer to that. Secondly, we have to remember that the investigations that we did were a long time ago. My sense is that Essex is not exceptional. My sense is that all the issues which have come out of the cases which I looked at, you can see in other places, not necessarily in exactly the same way, but just thinking about it, the absence of leadership, the failure to use the duty of candour, not communicating effectively with patients, the safety issues around ligature points, the failure of the serious incident review, and the absence of training and development. These are still issues which the NHS has to address generally, not just in Essex.
One of the points that you've made in relation to, for example, Matthew's case, is the severity, or for example, the high number of instances of maladministration.
Yeah.
To what extent is that kind of level of seriousness reflected across the country, or is it something like that might make Essex unusual?
It's possible, yes. I mean, there are, in my time, there were half a dozen very big health service issues where you would have the same number of serious failures. And they weren't confined to Essex. They were in Bristol, they were in Wales, they were in other places. What makes the Essex situation that I looked at so poignant is that all this happened with Mr. R, and then it happened again. When there was clear warning that this was the issue, there were lots of regulators about, but nothing changed, and that is an indictment of the system. And then on top of that, it took us until very recently to get to a public inquiry. You know, we were reassured that an independent inquiry would be fine, and it wasn't, because they refused to cooperate. The clinicians refused to cooperate with it. Ministers tried to back that away, but in the end, justice was done.
You've explained to us changes that you would advocate to make the PHSO more effective.
Yeah.
If there was one key area, in your view, in relation to mental health services generally, that could be addressed for real improvement, what would that be?
So there are three, if I may.
Yes.
First of all, the duty of candour does not work. And unless people are prepared to say what happens in difficult cases, clinicians, then these kinds of situations are going to repeat themselves. The law doesn't work. It wasn't as Robert Francis proposed it should be in 2014. It needs to be changed. Secondly, and related, the law on whistleblowing doesn't work either. And I have had dozens of clinicians get in touch with me and say, I want to raise this issue, but if I do, I'm going to lose my job, I'm going to lose my career. That is unacceptable. but it does need to change, and it can only change by a legal change. And the third thing, which I think is very, very important in mental health, is there needs to be continuing professional development and training of those people involved. It's not fair to expect clinicians and managers to undertake these immensely difficult supervision roles and caring roles unless they have access to the professional training that they need. And one of the things that I'm most pleased about when I was Ombudsman was that we introduced, you haven't mentioned it, but it is important, we introduced the complaints good practice framework, which is a way of encouraging frontline bodies to adopt model good practice in complaints handling and provides them with professional training to do their jobs better. And I think in the last year, PHSO got accreditation for 600 NHS employees, and 700 individuals participated in the training. Now that's not enough, it's a tiny fraction, but it shows how important, how much thirst there is for professional development. And yet we had a national report into training and development in the NHS, which was published in 2022, the Messenger report, good piece of work. Sir Gordon Messenger wrote it. Where has it gone? It's disappeared. As far as I can see, it may come again, but it's not been implemented. And without these things, it's not going to fundamentally change.
You've mentioned three things. May I ask you about one of them? And that is whistleblowing. And you say the law doesn't work.
Yeah.
Could you just explain a little bit more what you mean by that?
Yes. So the reason that I use the protocol on emerging concerns was because I discovered through my supervision of University Hospitals Birmingham that the chief executive at the time had sent more than 20 clinicians to the GMC when they wanted to blow the whistle or did blow the whistle about patient safety in Birmingham. And so the situation was and is that when good and honourable people try to raise patient safety issues, the response of the NHS leadership has been to discipline them by referring them to their regulatory body, in this case the GMC. That is wrong. It should not have happened. The law is weak at the moment in comparison to the European Union and other countries. You need a lot of money in order to fight people who send you to the tribunals to resolve these issues. And there is, unlike Scotland, there is no national whistleblowing authority that clinicians or managers can go to say, help me, advise me what to do, give me support. In Scotland, the Ombudsman has that role. In England, the Ombudsman could have that role. Other people want to create a separate body. But I know that these people are brave, but they're lonely, and they don't get the support that they need in order to bring issues like the ones that we've been looking at to the fore. And these are people on the front line, and if they don't get a chance to do it, then these issues are not going to be properly raised.
Thank you. Chair, those are the questions that I have for Sir Rob at the moment. Unless you have questions, might I ask that we rise just for 10 minutes to ensure there aren't any further questions that need to be put? Chair, just two further questions. First of all, just following on, Sir Rob, from what you said about whistleblowing, could you just acknowledge that this was also one of the features of Melanie Leahy's case? For an investigation of mental health issues, it's a real rather than a theoretical issue that staff were silenced.
So, could you
So
just
in Melanie
repeat?
Leahy's case,
Yeah.
there was an allegation that a member of staff was told to keep stum.
Yes.
Do you recall that? You
Yes.
mentioned it in your statement. So I think the point here is you were talking about whistleblowers, and the question I've asked is directed to the fact or the point that this is something that actually has happened in one of the cases we've been looking at.
That's absolutely right. And remember that I said there were three issues.
Yes.
One of them is the duty of candour,
Yes.
which was broken by the instruction to keep stum on anything. So I think that's absolutely right, and I accept that.
In your missed opportunities report, you make various recommendations, including for, I think it's an NHS improvement investigation to take place. Did that investigation ultimately take place?
No. What happened was that, I mean, there were a number of investigations going on when we completed the missing opportunities report. One was a police investigation, one was a health and safety executive investigation. We therefore held back from making a recommendation for a public inquiry until we sent we laid the report on missed opportunities before Parliament. And at that time, we said there should be a public inquiry.
So was that because, for various reasons, the NHS improvement investigation had not taken place?
Well, what they said was they wouldn't do it. They told Parliament this. They wouldn't do it because there was now going to be an independent inquiry which would perform the same role. And as we know, that inquiry collapsed. So NHS England didn't carry out what they had promised.
Thank you very much. Chair, I've got no further questions for Sir Rob.
Sir Rob, thank you very much indeed.
Thank you.
Thank you for your courtesy.
Thank you. Chair, we're now going to move to a different phase of the evidence. And with your permission, I'm going to leave and I'll be replaced by a colleague. Thank you. Sir Rob, thank you very much.
Good afternoon, Chair.
Good afternoon, Mr. Muzue.
Chair, as indicated by Mr Griffin, we're now going to hear a presentation from another colleague in the Council to the Inquiry team, Dr Tabo Ilozwe. He's going to update you on the evidence the inquiry has received so far relating to services provided by the trusts in Essex and where those services were being provided. And that will be then followed, as we understand it, by a short presentation touching on the issues raised, which will be delivered by Stephen Snowden, King's Counsel, afterwards.
Thank you.
Chair, this presentation will provide an overview of the information that the inquiry currently holds in relation to the mental health services provided to NHS patients from Essex over the relevant period, the period that the inquiry is investigating, and also regarding the locations of the facilities through which those services were delivered. My aim in this presentation is to summarise the evidence that has been received from the Commissioners of Mental Health Services and from the providers of those services about where, what, and from whom mental health services were delivered to inpatients under the care of the Essex Trusts. I'll begin with a brief word about the context of the Rule 9 requests that we sent out asking for information on this matter. The inquiry is tasked with investigating the circumstances surrounding the deaths of mental health inpatients under the care of NHS trusts in Essex, and therefore it is of course focused on the inpatient care delivered by those NHS trusts in Essex. However, as set out in the explanatory notes in relation to scope of the terms of reference, the inquiry's definition of inpatient death includes deaths which occurred in other settings. And Amanda, please, would you put up the amended explanatory note in relation to scope? This explanatory note is, of course, available on the Lampard Inquiry website. And under the definition of inpatient death, subsection A begins those who died on an NHS mental health inpatient unit. But then it continues, or in receipt of NHS-funded inpatient care within the independent sector. At subsection D, we see the definition includes those who died while awaiting an assessment includes those who died within 3 months of transfers, including transfer to a physical health setting or to an out-of-area mental health service. At E, we have those who died whilst awaiting an assessment under the Mental Health Act. And then at F, those who died while waiting for a bed in a mental health inpatient unit within 3 months of a clinical assessment of need. Next page, please, Amanda. And then G and H. G, as recently amended, now includes those who died within 3 months of a mental health assessment provided by the trusts or on behalf of the Essex local authorities, which did not result in admission as an inpatient. And H includes those who died within 3 months of discharge from any of the above units. That can now be taken down, please. In addition to the explanatory notes, one further matter of context arises from when the inquiry was considering core participant applications. Chair, you at that stage determined that the inquiry's definition of inpatients includes mental health inpatients who were under the care of NHS providers in Essex, but who were placed outside Essex, either because there was not enough bed space in Essex or due to needing specialist services that were not at the relevant time available in Essex. Therefore, the range of mental health services which are relevant to the inquiry is broader than merely the services provided by Essex NHS trusts within Essex inpatient facilities. It also encompasses the services provided by those NHS trusts in non-inpatient settings, which could or should have led to admission, and/or those which were provided by those trusts to the patients in the weeks following discharge. It also encompasses the mental health services provided to patients who were admitted into NHS inpatient facilities for physical health in Essex. And it encompasses the inpatient mental health services provided by NHS trusts outside of Essex and by independent providers, both inside and outside of Essex. The inquiry, therefore, has sent requests for information to numerous organisations in order to identify what all these services were and where and by whom they were provided. The inquiry began with Rule 9 requests for information to EPUT as the largest provider of NHS mental health services in Essex, and to the 3 integrated care boards who are responsible for commissioning core mental health services in Essex, and also for funding placements of Essex NHS patients with private providers and external NHS trusts. Those integrated care boards, or ICBs, are Mid and South Essex ICB, Suffolk and North East Essex ICB, and Hertfordshire and West Essex ICB. EPUT was asked to set out the mental health services it had provided over the relevant period, and the locations at which those services were provided. In the Rule 9 request, the inquiry used the term wards and services to refer to that location and service data that was sought. EPIT was also asked to identify all the private facilities and NHS trusts facilities outside of Essex into which patients under its care had been admitted for inpatient treatment. In the request, the inquiry used the term out of area to refer to that group of providers and facilities. The ICBs were asked to explain the circumstances in which placements of patients outside Essex occurred and to identify all the out-of-area providers with whom patients under the care of the Essex Trusts had been placed. And then subsequently, after those two initial requests for information, additional requests were sent to Nelft in a similar vein to that sent to EPIT, to the private providers known to have inpatient facilities in Essex, namely Priory, Signet, St Andrews Healthcare and Nest Healthcare, and to the NHS trusts responsible for the physical health hospitals in Essex. They were all asked about the wards and services they provided. And then a list of providers was compiled from the initial response the inquiry received from EPIT and the ICBs, and all of them were asked about the inpatient facilities into which they had admitted Essex NHS patients over the relevant period. Finally, NHS England, who are responsible for commissioning specialised mental health services for Essex patients, was asked similar questions about the out-of-area providers of those specialised services, similar questions to those the ICB had been asked about their core mental health providers. In total, the inquiry contacted 46 organisations asking for information on those matters. 29 of them have provided statements to date, one of them remaining in draft, and 28 organisations provided details about their inpatient units. In total, the inquiry has received so far information about 870 wards in 249 facilities. The inquiry has also received information from EPIT, NHS England and the ICBs about 66 out-of-area organisations who had provided care to Essex patients. And Nelft and EPIT identified 175 distinct teams that were responsible for providing potentially relevant non-inpatient care. All of this information that the inquiry has received on this topic is detailed and wide-ranging, however, it is not yet complete. This is not merely because of the providers who failed to respond appropriately. In addition, the organisations who did respond were not all able to respond in full in the time available between the requests and this hearing. The majority of them reported limitations arising mainly out of difficulties obtaining historical information for the early part of the relevant period from paper-based records. I would give two brief examples. Hertfordshire Partnership Foundation NHS Trust, or HPFT, referred to an archive of 20,000 boxes of paper records and a microfiche archive of 43,000 patient records, covering the period before its electronic records began in 2006. HPFT said they would need to review one by one all of those documents in order to identify all the admissions of Essex patients. The ICBs were only able to retrieve information about providers utilised by their placement teams since 2014 because the relevant information had not been collated from the records before that date. Therefore, the ICBs told the inquiry that providing complete pre-2014 information to the inquiry would require them to undertake a manual review of nearly 5,000 individual patient records. The limitations of this nature, and there were numerous of a similar nature, provide insight into the manner in which records have been created and maintained by the organisations responsible for delivering mental health care over the relevant period. They also indicate the challenges that such issues with historic record retention and categorisation will raise to the ongoing work of this inquiry. In this paper, I will not attempt to reproduce, this presentation I should say, I will not attempt to reproduce all the information which the inquiry has received on this topic. The witness statements and the key exhibits from each organisation have been included in the hearing bundle, and the raw data is available for scrutiny. And the key exhibit in this case is an Excel template that was sent to each provider and with the request for them to populate it with the data sorts. What follows in this presentation are selected themes and data points which have been drawn out and summarised to assist those listening to develop a general appreciation of what services were delivered by what providers, where and when. All of the information and data presented has been reproduced as presented by the providers, with the exception of a few postcode adjustments using publicly available information from the CQC website about facility location. There has been no attempt to verify or confirm or adjust the information. Therefore, any inaccuracies present in the underlying data will be incorporated into the summaries and analyses that I will present. And the presentation of that data does not signify any acceptance of the accuracy of that information by the inquiry. The aim at this stage is simply to provide an overview of what information has been received in a form which enables some insight to be gained about the nature and content of the current evidence. With that, I move on to providing that overview, and I will do so in 4 sections. Firstly, I will identify the Essex NHS trusts over the relevant period. Secondly, I will describe the inpatient services that were provided by those trusts. In the 3rd section, I will set out other locations in which Essex patients were admitted. And finally, I will identify some of the most relevant non-inpatient services that were delivered by the Essex NHS trusts within Essex. Turning then to section 1, who are the trusts? Amanda, would you please put up table 1? And please move on to the 2nd page. Beginning with EPUT. EPUT was formed in 2017, 1st of April 2017, the final row of this table. It was formed by the merger of South Essex Partnerships University NHS Foundation Trust, SEPT, and North Essex Partnership University NHS Foundation Trust, NEPT. Both NEPT and SEPT began operating early in the relevant period. We can see in row 1 and row 3 of this table that they were named foundation trusts in 2006 and 2007 respectively. And now, Amanda, if you go to the 1st page, please. They were both formed very close to the start of our relevant period in 2000 and 2001. That's the 2nd row and 3rd row of the table, 2nd and 3rd columns respectively. Prior to that, NEPT, which was previously called North Essex Mental Health Partnerships NHS Trust, was formed as a merger of 3 trusts that had provided services in North, West and Mid Essex. They were North East Essex Mental Health NHS Trust, Mid Essex Community and Mental Health NHS Trust, and Essex and Herts Community NHS Trust. SEPT's immediate predecessors were Tameside Community Healthcare NHS Trust and Southend Community Care Services NHS Trust. The other 2 providers of mental health services in Essex are NELFT and the predecessors of NELFT, and that information will be provided in due course, and HPFT, who I've already mentioned. And they run a specialist inpatient and community learning disability service throughout North Essex, and they've done so since 2010. HPFT is responsible for one inpatient unit in Colchester, which is called Lexden Hospital, and it became a foundation trust in August 2007. None of its predecessors before 2010 are relevant to the inquiry's purposes because only its activities within Essex are relevant from the perspective of naming the NHS mental health trusts. Thank you. Can that come down, please? So those are the mental health trusts. It's also relevant to mention the NHS trusts who provide accident and emergency services across Essex. These are currently Mid and South Essex NHS Foundation Trust, East Suffolk and North Essex NHS Foundation Trust, and the Princess Alexandra Hospital NHS Trust. Mid and South Essex NHS Foundation Trust, or MSEFT, operates Southend Hospital, Basildon Hospital, and Broomfield Hospital in Chelmsford. East Suffolk and North Essex NHS Foundation Trust, or ESNEFT, operates Colchester Hospital, and the Princess Alexandra Hospital NHS Trust, or PAHT, operates the Princess Alexandra Hospital in Harlow. Trusts like these and their predecessors are sometimes referred to as acute trusts due to the emergency services they provide. And the inquiry sent out requests for information to all three to obtain information about how mental health care was provided over the relevant period to patients with mental health difficulties who presented at their A&E departments or were admitted to their wards with coexisting physical health issues. All three trusts provided similar evidence. They have no dedicated departments or facilities for mental health services and do not provide mental health services themselves. The mental health services required by their patients over the relevant period were delivered by either EPAT or its predecessors or NELFT and its predecessors. The acute trusts would treat patients for their physical conditions and then seek support from or make a referral to the appropriate mental health trust for the mental health care required. PAHT also explained that on occasion they will have patients who are medically fit for discharge but require a mental health bed and their discharge is delayed because there is no mental health bed immediately available. PAHT explained that those patients will remain under joint care with the mental health care managed by EPAT or NELFT. MSEFT and PAHT told the inquiry that they employ no dedicated mental health professionals. However, in the case of ESNEFT, since April 2022, that trust has directly employed 2 registered mental health nurses based at Colchester Hospital to help with the support of patients under the age of 18 years. The mental health trusts, EPAT and NELFT, retain responsibility for the mental health needs of the patients, but ESNEFT's nurses support the care provided. They provide additional guidance, liaison, and multi-agency communication during office hours on Monday to Friday. They also provide support in the emergency department if there are delays with discharge. And if the patient is admitted, they will review patients within 1 working day to commence care planning, and following daily reviews on Monday to Friday, they will support the care which is ultimately under the responsibility of the Mental Health Trust, NELFT. NELFT also holds responsibility for the patient's post-discharge care planning and risk assessments, but ESNEFT's nurses will support those discussions too. Before leaving the issue of the NHS mental health trusts, the Essex NHS trusts, I will finally say a word about the local authorities. This is because the local authorities have the statutory responsibility for arranging and managing assessments under the Mental Health Act. They employ approved mental health professionals, or AMPs, who coordinate assessments by approved clinicians and make applications for admission under the Mental Health Act on the recommendation of those clinicians. Although the local authorities are of course not NHS trusts, they should be noted because they are obviously public bodies and the AMP function is directly and importantly relevant to the work of the inquiry. Essex has 3 local authorities: Essex County Council, Southend Borough Council, and Thurrock Council. With that, I turn now to the second section of the overview, identifying the inpatient mental health services provided by the Essex NHS Trusts. The evidence we've obtained to date indicates that the trusts have delivered inpatient care from 120 different wards in 34 different facilities over the relevant period. The vast majority of those wards and facilities were run by EPIT. Amanda, please would you put up table 2? The first page of this table shows the start of the facilities that EPIT ran in the north, or have run in the north. Please turn to page 2. That continues through to the second half of the second page, and then we see the start of the southern facilities with Basildon Hospital, etc. So page 3, please. Continuation of the facilities in the south, and then the final page. We see only 2 facilities run by the other 2 trusts, NELF and HPFT, Mascos Park and Lexden Hospital. The remaining 32 were under the responsibility of EPIT. Thank you, that can come down. Please would you put up video 1? This image is a map showing the location of all those 34 facilities across Essex. I will not read out the labels, just as I didn't read out each name from the table, but I will leave it up for just a moment to give everyone an opportunity to cast their eyes over the map and appreciate the distribution and clustering. Thank you, Amanda. Please would you take that down now and switch to video 2. If you play that now. What we have here is the same or a similar image, but this time the blue spots showing the locations have been replaced with bar charts. But these charts show the exact same 34 locations. The additional information they contain at this stage is they also show the specialities provided at each of those locations. And I'll say a little bit more about those specialities in a moment. I've referred a few times to the figure 34, but not all of those facilities were in place for the entirety of the period of the inquiry's investigation. The number of facilities has varied from year to year. And the next video that I will show demonstrates that change over time. So Amanda, if you play please now video 3. The date, the year is in the bottom left, and each time the bar chart grows, it shows that distribution of specialties that I'll speak more on. In terms of the number of facilities, the final point I make, at the start of the relevant period, we know there were 23 facilities, and the peak was in 2009, when it rose to 27, and then since 2019, there have been 16 facilities all run in Essex. "15 of those facilities are run by EPIT, and just one, the Lexden Hospital, which we can see in the top right of this image in yellow, is the sole facility run by a different provider, run by HPFT. I'll say a little bit more about the specialities now. You can see them identified in the bottom right of this image in the legend to the bar charts. Some of the specialties have been combined together to make the bar chart easier to read, easier to see. The majority of those specialties have been provided throughout the relevant period. Those are adult mental health and PICU, mental health assessment units, CAMS, but not the CAMS PICU, forensic low secure and forensic medium secure, and learning disability and older mental health. Later on in the relevant period, the mother and baby unit, which is what MBU under other stands for, and the drug and alcohol unit and the PICU began to be provided. The MBU was provided since 2010, the CAMS PICU since 2012, and the drug and alcohol unit since 2022. These are bar charts. They demonstrate the distribution of the number of beds that each specialty delivered at the location. The higher the bar, the greater the number of beds. Amanda, if you take that down now and switch to figure 1, please. This figure also gives information about the number of beds in a clearer and more quantitative way. It shows how that level of inpatient service provision, the bed numbers, varied over the relevant period. The absolute figures are not accurate. They're likely to be a slight underestimate, but it is likely that the trend is correct and it is clear. It shows a steady and significant decline in the number of general adult and older adult psychiatry beds. Older adult is depicted in purple, general adult depicted in blue at the bottom of the graph. There has also been a reduction in learning disability beds, but the remainder of the specialties have remained reasonably stable. Please could that come down? We also asked the providers for details about which wards were single sex and which wards were mixed sex. Would you put up figure 2, please, Amanda? This second chart shows the proportion of the beds that were on single sex or mixed sex wards. So out of the total number of beds provided in any given year, with year along the bottom, what percentage were mixed in purple, what percentage were male in blue, what percentage were female in the light red. And we see an increase in the number of single-sex beds over the relevant period, but by the end, by 2003, still almost half of the NHS mental health beds in Essex remained on mixed wards. Thank you, that can come down. I turn now to section 3 of my overview. And this is the out-of-area inpatient care delivered to the Essex patients over the relevant period. What I will do is show a series of map charts to provide an overview of the geographical spread of the care provided to Essex patients in private facilities and in non-Essex NHS trusts across the country. But before I ask for them to be shown, I must emphasise, and it must be understood, that this data set is very incomplete. It is based on the provider list that the inquiry obtained from EPIT and from the ICBs, and it's based on the information that the inquiry received from the providers who responded in time about the number of Essex patients they had admitted into their facilities over the relevant period. The majority of providers were unable to provide complete figures for the entire relevant period because they did not have electronic records for that entire period, and they were unable to review their paper-based records in the time available. At present, the total number of out-of-area admissions from all the providers who were able to give figures currently stands at over 5,800. However, clearly, in the light of what I just said, and in the light of all the issues noted previously, that figure is of limited utility at present. Amanda, please would you put up item 9, figure 3, please, before the table. For those 5,800 admissions that we know about, we know they took place in 249 facilities across the country. This map shows the location of every mental health facility that the inquiry has received information about to date. Each postcode is marked in red, and shaded in blue is the unitary authority responsible for the location of the facility. Thank you, that can come now. I will say a brief word about the reasons for the placements. It would be wrong to assume that all of those placements were inappropriate. NHS patients can be admitted into private units or into units outside the geographic area where they are registered with a GP or where they reside for a variety of reasons. A list of reasons has been compiled from the evidence received from the ICBs and from NHS England. The first reason identified was where there is limited national provision for a service. And there were some key specialised inpatient services which have not been provided by the NHS trusts in Essex at any stage during the relevant period. Those are specialised eating disorder services, high secure forensic services, and inpatient personality disorder services. So where those services were required, then an Essex NHS patient would need to go outside of area in order to receive the care they required. Furthermore, even where there were specialised services potentially available in Essex, there may be services in another part of the country where a clinician with a special interest or an expertise in the specific mental health matter would give a benefit to the patients from the care and treatment that they could deliver, and therefore potentially deliver better outcomes or a shorter length of stay. Second reason for out-of-area placements might be patient or family choice. A third would be capacity gaps in the local service due to, for example, a lack of beds or insufficient clinical capacity. Fourth reason could be criminal restrictions or other matters from the Justice Department requiring placements in other areas. A related fifth reason might be risks to victims or an exclusion zone or other safeguarding considerations requiring patients to be placed elsewhere. A sixth reason would be potentially geographical proximity to the patient's home address or to their family. Seventh, to maintain patient confidentiality. For example, if staff members required treatment and they were employed by a trust within Essex, they may be placed out of area. A further reason would be patients who are admitted as an emergency or via police arrest whilst they're temporarily in another area. And finally, if patients move away but remain registered with a GP in Essex, then that would also be categorised as an out-of-area placement. As things stand, the inquiry has virtually no quantifiable data on how the placements which did occur were distributed between these potential reasons. And it may well be impossible for the inquiry ever to obtain reliable and complete data of that nature. The ICBs have said they are continuing inquiries for information which may lie with them, but they've also said that other data would be with the NHS providers or are simply not compiled and merely recorded in individual patient notes. On the part of EPUT, and here please Amanda if you put up table 3, EPUT have said that they do not maintain a central log of out-of-area placements, but they did provide the following table of figures on the number of placements that occurred over the relevant period. And they separated those figures into those occurring in NHS facilities and those occurring in the independent sector. And then we have other. The vast majority, as we can see, are in the middle column, in the independent sector, and there seems to be an increase over the years, but the information provided isn't complete, so that is not necessarily reliable. And the top of the figure, the top of the table, is of course the end of the relevant period. Thank you. That can come down. What will be shown next are a series of maps illustrating the distribution of admissions outside the country. If we start with the next video, please, and pause at the beginning. You see at the bottom all out-of-area facilities in the bottom left. And what this map shows is a distribution of the number of placements out of the 5,800 the inquiry has been told about. For the background shading of the unitary authorities, where that colour is darker, so in Essex, in Cambridgeshire, then it shows a higher number of placements occurring in that area. Where that shading is lighter, then it's a lower number. And that data, quantifiable data, is reflected in the hotspots that you can see distributed across the map. They show the same data, but now localized to the postcode or the longitude and latitude at which of the facility into which the admission occurred. So this map shows all out-of-area facilities, excluding therefore the facilities within Essex. And we can see that the cluster and the heat map makes it clear that there was a concentration in the area around Essex, as one would hope and expect, but the distribution is all over the country. Thank you. That can come down. If you put up the next one, please. Forgive me, if you move on to the next. Thank you. What we see here at 2 is the NHS out-of-area facilities. And so these are NHS trusts outside of Essex into which Essex patients were admitted. And the map is on the same basis, with the intensity reflecting higher numbers. Thank you. If you move on to the next. Here is the independent facilities, with a slightly broader distribution in terms of the geographic spread. Thank you. The next. Here we have providers of specialised services. So specialised services including the personality disorder, high secure forensic, and eating disorder I mentioned earlier, but also forensic, low and medium secure, and CAMS. And finally, these will be non-specialised services, the core mental health services, older adults, acute adults, PICU, etc. Now, this evidence about the spread of these admissions is not presented in order to invite any judgment about what has been depicted. We know that we cannot reach any conclusions at present about the proportions of placements that were appropriate or the appropriateness of the place in which treatment was received. We can't draw any of those conclusions from the information currently available. The objective in providing these maps at this stage is to assist with visualizing the spread of the location in which care has been delivered to those who might be within scope of the inquiry. Thank you. That can come down. I conclude with the 4th section of my overview, touching on the non-inpatient services that were provided by the Essex NHS Trusts. EPIT has provided the inquiry with a detailed account of the history and framework of the teams which hold a gatekeeping role over inpatient admissions in the Trust. These teams have responsibility for assessing patients to decide whether or not they should be admitted. and I'll give a brief overview of the teams identified by EPITS. They include the crisis and home treatment teams. These were introduced progressively across Essex from the early 2000s. Second team is the A&E liaison team. They provide a mental health liaison service in acute hospitals. I already referred earlier, from the perspective of those hospitals, to the fact that the care required from a mental health perspective within their facilities is provided by the mental health trusts. And EPIT have informed the inquiry that that care was initially provided by individuals from the community and inpatients mental health teams working on rotas, but then progressively dedicated teams were introduced across Essex to provide that liaison service. In some areas, the crisis team would have a dual role within acute facilities and in the community. In other areas of Essex, it was a specific and separate mental health liaison service. EPIT also told us about the crisis response service. This is a service that's much more recent. They've had it in place since 2020, and it receives and triages urgent calls that are made via NHS 111, option 2, if patients are in mental health crisis. If thought to be required, the crisis response service can also carry out a face-to-face assessment of the patients following the telephone triage, and they will have a gatekeeping role in deciding whether admission is required. A fourth service with a gatekeeping role is the Urgent Care Department in Basildon Hospital. This is again another recent service which has been delivered as an alternative to A&E for patients who present in crisis. EPIT also told the inquiry about a variety of dedicated older adult gatekeeping teams, and they told the inquiry that the forensic inpatient units and the mother and baby units carry out their own specialised gatekeeping process, which doesn't go through the crisis or any of the other teams, but requires an assessment to be carried out on the ward, on the unit, in order to determine whether admission is required. In relation to CAMS, EPIT told the inquiry that they previously organised gatekeeping of admissions for CAMS patients. That was over the first decade of the relevant period, and it was done in the Trust's only CAMS unit at the time, which was Longview Ward on Turner Road in Colchester. They told the inquiry that from 2007 in North Essex and from 2009 in South Essex, the Trust had a CAMS crisis outreach team which undertook gatekeeping. Then in 2015, EPIT informed the inquiry that CAMS community services were passed to NELFT, and following this, that admissions were arranged by direct liaison between the NELFT CAMS crisis teams and the EPIT CAMS wards. So those are gatekeeping assessments. I turn now to talk about the Mental Health Act assessments. I've already noted that they fall under the statutory responsibility of the local authority. However, under Section 75 of the National Health Service Act 2006, the local authorities were empowered to enter into agreements with NHS trusts in order to exercise their functions. And in 2006, the 3 Essex councils entered into such an agreement with EPIT for EPIT to provide Mental Health Act assessments between 9 a.m. and 5 p.m. on Monday to Friday. Accordingly, the Trust had AMP teams who delivered that service. Outside those hours, the responsibility for the assessments remained with the local authorities who had emergency duty teams. EPIT informed the inquiry that the Section 75 agreements for EPIT to provide those daytime AMP services came to an end late in the relevant period. With Essex County Council, it came to an end in 2019. With Thurrock Council, it came to an end in 2021. And with Southend Borough Council in 2023. And the councils took back the AMP roles centrally. Information about NELFT's non-inpatient facilities will follow in due course. HPFT have not yet been asked about its non-inpatient services because the inquiry received confirmation of its role as an Essex NHS Trust only very recently. Therefore, moving forward, further information will be sought about the scope of the learning disability services that HPFT provides in North Essex. Chair, that concludes the 4 sections that I wish to provide by way of overview. Moving forwards, as I noted, the data the inquiry has received so far remains incomplete, and it will be finalised. It will be finalised by gathering pending evidence from the providers who did not or could not respond in time for this hearing. And the inquiry will also ensure that the commissioners have identified all the providers that they can practically identify from their records so that they can also be contacted. For the reasons I've touched on already, it is unlikely to be possible to obtain a perfect record of every location and every context in which any patient who falls within the inquiry's terms of reference may have been treated. However, the inquiry will endeavour to achieve a picture that is as complete as possible while giving proper regard to considerations of proportionality. The analyses that I have illustrated in this presentation will be continued and expanded in order to ensure that the data are presented in the most useful and instructive way, and the inquiry will seek the assistance of its expert health statistician, Professor Donnelly, to complete that work. The final analysis will represent important context regarding the care that was delivered to the patients within scope of the inquiry's terms of reference. Of course, each of the providers will also be asked to provide information about any deaths occurring amongst the patients from Essex under their care, which may be in scope of the inquiry's investigations. And the data may also assist in guiding the selection of the most appropriate regions to use for the comparisons that will be needed to understand how similar or divergent the care delivered in Essex was to the rest of the country. Chair, that concludes my presentation to you this afternoon.
Thank you very much indeed, Mr. Losway. Really clear. Thank you.
Chair, we're now due to hear from Stephen Snowden, King's Counsel. I was looking at the time. I'm not sure if a 10-minute break would be appropriate at this stage. I think we've been going just over an hour. I see Mr. Snowden is indicating he's not going to be very long, perhaps.
Well, then we'll go straight ahead. Thank you. Mr. Snowden, good
Chair,
afternoon.
Good afternoon. It's a pleasure to sit here for a third time. We and others, core participants, are really grateful indeed to my learned friend and to your inquiry team for the update on where we've got to about the numbers who may have been treated in different places in and outside Essex as defined so far. We're very grateful for the opportunity to respond, and I will do my very best to make it for no more than 10 minutes, and we can all then have a cup of tea and go home, I hope. My learned friend concluded, and his paper concludes, that it is unlikely to be possible to obtain a perfect record of every location and every context in which any patient who falls within the inquiry's terms of reference may have been treated. And we suggest that begs at least 3 questions. First, what is the purpose of gathering this data? Second, how can your inquiry do as much as is practicable and proportionate to fulfil that purpose? And third, we're going to touch on the terms of reference in relation to this data. So the first of those 3 points, what is the purpose of gathering this data? And we invite the inquiry to take a step back now that substantial amounts of preliminary data have been obtained. So we suggest that the purpose of gathering the data must always be sensitive to the concerns of the families and the patients and what actually happened to them. We don't need to investigate numbers just for numbers' sake. We don't see that. We respectfully suggest that's not part of your role. And we suggest inquiry should focus its efforts on the actual people, the families, the friends, the survivors, who are the interested parties before it. The questions that should drive this inquiry's investigations, we suggest, are principally, where were they treated? How and by whom were they treated? What do they have to say about the nature and the quality of the treatment that they were given? And we suggest that the inquiry's ability to make useful findings in relation to those about whom it has no first-hand evidence, so those theoretically scattered around the country, whose names we do not necessarily know, who are not necessarily participants, not necessarily core participants, and haven't necessarily or won't necessarily give you witness statements. So your ability to make useful findings about that spread of patients will inevitably be limited, even if you did have a perfect record of how many people had been sent to various places. Because we note that, as my learned friend said, and in his helpful paper, the objective for providing the maps that we've just been taken to is to assist with visualising the spread of locations in which care has been delivered to those who might be within the scope of the inquiry. And we just pause there and we express our concern, with respect, hoping that it will cause the inquiry to pause and think, that the focus on the hypothetical scope of those who might be within the scope of the inquiry is wrong if it's pursued at the cost of those who have actually made applications for CP status, who are actually participants in the inquiry. We know who they are, we know, you will know in due course where they were treated, and we suggest that that is likely to be a more fruitful ground for you to search, interrogate and understand how poor the treatment was than ascertaining numbers in far-flung parts of the country. Clearly it will be important, we accept, to know how many inpatient deaths occurred in Essex, and that is one of the tasks for your statistician. But if it is impossible to say how many people may have been treated where or how, then in a sense we say so be it. The data on wards and services is not essential to your what's expressed to be one of your functions, which is to determine how similar or divergent the care delivered in Essex was to the rest of the country. Knowing the spread of where patients were treated won't necessarily answer that question for you. Because, for instance, if an expert in your inquiry gives evidence in due course that a minimum standard was in place, and if you determine through the case studies that the care provided in Essex fell below that standard, then the divergence question falls away. You don't really need to know the numbers elsewhere. And you don't necessarily need to compare how the two patients who were treated in the northwest of the country fared against the several hundreds about whom you'll have real evidence in Essex. So we invite your inquiry to be clear and to engage with the core participants about the purpose of gathering this data, and to be cautious not to elevate the data above the evidence of real experience of real patients. So that's the first point, the purpose of gathering the data. The second, how can the inquiry do as much as is practicable and proportionate to serve the real purpose of gathering the data? And we say, we invite the inquiry to consider what to do about the gaps in the material that Malone and friends kindly identified for us, in conjunction with core participants and in conjunction with your expert statistician, and only to dig deeper into the data of who was spread where, once you've received the core participants' accounts, once you have the full range of Rule 9 statements at your fingertips. Because we suggest it must be difficult for the inquiry to assess now whether it's worth using your own personnel to conduct difficult research that may be important to obtain, as are some other inquiries have done, send out paralegals to all parts of the country to analyse boxes of documents. Other options open to you may include dispensing with some of the areas where you don't have that detail, because you may feel, when you've seen the full range of evidence and the full range of Rule 9 statements from core participants, that it's not necessarily to pursue to its absolute detail the far-flung parts of the country. The third point we'd like to make on behalf of our core participants arising from this paper and this presentation is to do with your terms of reference. And Chair, we have already been in extensive correspondence with your inquiry team about your terms of reference. We note and are grateful that you have changed your stance as to the interpretation of some of the terms of reference. For instance, your focus on assessments is now most closely on those associated with inpatient assessments, as footnoted in the paper and as trailed by your leading counsel to the inquiry at the opening of these hearings. And we do suggest that it is important to make sure that we are, in your final version of the terms of reference, your final version of your understanding of the terms of reference, when you take stock of what's transpired at this hearing, before we move forward, and the inquiry moves forward, in obtaining data and analysing it. You need to know the solid footing of what you know before you decide how much more you really need to know, if I can put it that way. One discrete issue, though, that arises about the terms of reference, and which is illustrated by this paper and the data you've heard, is the geographical scope of the inquiry. And if you'll allow me 2 minutes, I'll explain what I mean by that. We are grateful that this inquiry has the power, which we know we will use, to make national recommendations. But at the moment, we know the inquiry terms Essex to be coterminous with the local government areas of Essex, Southend-on-Sea and Thurrock, pursuant to the Lieutenancies Act of 1997. And we say now that your team have gathered some of the evidence that's been summarised for you today, that definition of Essex for the purposes for which this inquiry is convened is slightly arbitrary, and it offers no real gains, as this paper demonstrates. Essex patients were treated in many places outside the boundaries of those 3 local government areas. And they've been provided in so many places at various times that a complete list of the places they've been treated may never be ascertained. So we suggest that the inquiry should stand back and take more of an issue-based approach to the interpretation of its terms of reference, and should decide whether to admit consideration of deaths of Essex patients at other hospitals. Because the evidence you've obtained so far, which we're grateful for, suggests that healthcare provision for Essex patients doesn't follow the local authority boundaries. We note that NHS England have provided evidence explaining that when it uses the term natural clinical flow, rather than talking about out-of-area patients. So this seems to us to suggest a system in which the boundaries set by the inquiry, the geographical boundaries, don't necessarily dovetail with the boundaries the authorities themselves use, the providers or the oversight bodies. EPUT themselves have said they don't maintain a central log of out-of-area placements. And again, there's a risk that if you exclude those who were treated out of area, you may be excluding some who were treated out of area at EPUT's behest. So essentially we do say healthcare provision doesn't seem to follow those local authority boundaries, and we encourage the inquiry to be flexible about how it looks at its geographical boundaries. So those are the 3 main points, Chair, to make arising from the presentation, but if you'll permit me, there are just a handful of shorter points arising. First, to say something brief about disclosure. As with the other papers presented by counsel to the inquiry, we note that the information on wards and services is still substantially incomplete and is recognised to be so. And we suggest that engaging with the core participants as to how to fill the gaps, how to obtain more material, and whether it's necessary to obtain more material is important. Second point is on disclosure, not to the inquiry, but from the inquiry to core participants. And Chair, I hope you'll forgive me if I repeat in a slightly different way what I said the other day, because at paragraph 16 of this presentation, it is said the witness statements and the key exhibits for each organisation have been included in the hearing bundle, so the evidence and the raw data are available for scrutiny, and that must be scrutiny by us, the core participants. But this isn't in fact the case, because we see at one of the footnotes that some exhibits have been deliberately omitted from the evidence bundle because they're thought not to be so relevant for this hearing. We respectfully suggest again that core participants will feel better able to engage. I would feel better able to comment and respond to this paper if we had had greater disclosure by this stage of the material the inquiry holds. And it's difficult for us to attempt to verify or to comment on or to really substantially assist you with this paper in the absence of full disclosure. So again, Chair, we respectfully suggest that means we invite the inquiry to continue to give us better rolling disclosure and a platform on which we can interrogate that data. Moving to the next discrete short point is a reference to local authorities, which my learned friend touched on in your paper. At a few of his paragraphs, reference is made to the involvement of local authorities, but no local authority evidence, as far as we know, has yet been obtained. Certainly none has been disclosed to us if it has yet been obtained, and clearly this is an area where you will want to do further investigation. A separate short point is one in relation to mixed wards, where again, forgive me for just dotting around between points as you've invited a response. On mixed wards, we note the position in the paper as written and as delivered. We note that Dr. Corrale's evidence for EPUT in his second statement at paragraph 32 tells us that some localities have implemented what he calls a swing or a flexible system of wards and beds. So some operate as single sex when required, some don't, and then change. And we don't know, either on his evidence or from your learned counsel's paper, how far this represents practice across Essex. And again, that area, we suggest, is going to be important that it receives particular scrutiny, given the issue of sexual safety in your list of issues. Finally, one comment, if I may, in relation to out-of-area placements. And we note, as your counsel noted, the difficulties you've faced in determining the reasons for out-of-area placements. And this is an important area for the inquiry to investigate. It's in your list of issues. Dr. Davison's report touches on it. And it's important because, Chair, you will recall the commemorative evidence and the huge personal impact that an out-of-area placement of a patient or a beloved family member has on the family who are still here. And again, we note that your learned counsel has told us that virtually no quantifiable data are currently available on how the placements which occurred out of area were distributed, and it may be impossible to attain those. And again, we suggest this highlights the need for you to gather patient notes, to gather family and patient recollections, and to analyse this issue of out-of-area placements by case studies where the overarching national data is going to be difficult to obtain or difficult to understand. So, Chair, moving forward, we're grateful that for the delivery of the information that your inquiry has received so far. But if I may summarise really what I've said now and in the two previous papers really in 6 points. The first is we, at least as core participants, and we believe all the other core participants too, would be grateful for increased and greater disclosure on a rolling basis in good time through a usable platform. We'd be grateful to be involved in good time and substantial time before hearings happen. We would be grateful if there is an increased focus, as we know there will be as the inquiry moves forward, on drawing on the experience and perspectives of the different recognised legal representatives and core participants. The fourth point is the involvement of your statistician early in this data gathering process. We understand from the language used in my learned friend's presentation that the inquiry will seek the assistance of Professor Donnelly on this material, and we're grateful for that. If I may then be so bold as to put the fifth point this way, we invite the inquiry not to be so wedded to timetables that the participation of core participants and their recognised legal representatives, so that's us, is rushed and last minute. Because we do invite the inquiry to consider that the core participants will be able to bring their experience and their help to you to bear better if there's a little bit more time to digest material. So finally, we do invite you to consider your timetable for hearings going forwards. I've already made some suggestions about those. We'll make some more in written submissions at the end of this hearing. We invite you to consider that it might be helpful to adjourn hearings that are already listed. It might be helpful to change them to different dates, or to shorten or elongate the hearing spells that you have already identified. It might be a useful and cost-effective use of everyone's time and effort if the pace and the timing is driven by the evidence you obtain and the issues as they are developing, rather than necessarily sticking with a timetable which is set. So, Chair, we are really grateful for those papers. We're very grateful indeed for the opportunity to engage with them and look forward to doing more of that. Thank you.
Chair, that is the conclusion of the evidence to be presented today. The inquiry will not be sitting tomorrow, but we will sit again at 10 o'clock on Thursday when we will hear expert evidence about the provision of mental health inpatient care.
Thank you very much indeed. Thank you.
10 o'clock on Thursday.